Hello, I'm Jay Hirsch, Director of Administration for Columbia's ERM program. I'd like to invite you to today's panel on privacy and cross-border jurisdictions. Throughout the event, please submit your questions using the QA function at the bottom of the screen. Questions will be answered at the end of the event. Before we start, I'd like to tell you about an upcoming event that may be of interest to you. On December 3rd, we're going to have our ERM panel on conduct risk, the consequences of bad behavior. And now to present opening remarks, here is Bob Kostakopoulos, Deputy Academic Director and Lecturer in the ERM program. Bob.
Thank you, Jay. Greetings. I echo Jay in welcoming you to today's urgent and topical panel. Panels are an important and popular co-curricular activity of our ERM program. By way of introduction, the Basel Committee on Banking Supervision recently issued resilience principles where cyber security risks rank second to pandemics as disruption threats to bank operations. And just yesterday, the Wall Street Journal reported that the European Union has proposed new guidelines for data transfer across jurisdictions based on the EU's top court's decision that the 2016 EU-US Privacy Shield Agreement was in violation of the General Data Protection Regulation. The guidelines, when enacted, will require cybersecurity experts and cyber privacy experts to work closely together to address regulatory concerns. The moderator for today's panel is lecturer in the ERM program, Shahryar Shaghaghi, Chief Technology Officer, Quantum Xchange. We thank Shahryar for assembling such notable subject matter experts for today's panel. Shahryar, please take the podium. Thank you.
Thank you. Thank you, Bob. Hello, everyone. Thanks for joining this hopefully very informative session. With us today, I'm really excited that we have some very top gun panelists in their respective fields. I'll start off by giving you a quick introduction of each individual, and then we'll go right into the questions and discussions as it relates to data privacy and cross-border challenges and issues. Towards the end, we'll have a few minutes for your Q&A. So if you're interested, please submit your questions, and then we'll cover them towards the end of the session. So one of our panelists, Mark Clancy, I've known Mark for a number of years. He's one of the most respected and top gun, I would say, cybersecurity experts in the field. Mark has had an amazing career. Currently, he's the CEO at Authority Network. Prior to that, Mark was the CISO, or Chief Information Security Officer, and Vice President of Cybersecurity at Sprint, one of the largest telecommunication organizations. And during the time at Sprint, in addition to some of the key functions that he implemented, he was able to encompass the blending of cybersecurity functions with a fraud team covering both online and retail. He is the founder of Cyber Risk Research, a research consulting firm focusing on quantifying and making sense out of this to be able to make decisions around automation, analytics, and configuration of some of the cyber intrusions and attacks that are very well public, as you know. Over the course of the 25 years of experience, Mark has covered everything from data centers to boardrooms, and he's also testified before the US Congress, to the House of Homeland Security Committee, House Financial Services Subcommittee on Capital Markets and Government-Sponsored Entities, and the Senate Commerce Committee on Cybersecurity Issues. Welcome, Mark. The next distinct panelist is Joe Faciponti. Joe is a partner and an attorney at Murphy McGonigal. He focuses on data privacy, which is the heart of our subject today, compliance, and white-collar crimes. He used to be a prosecutor at the U.S. Attorney's Office for Southern District of New York, where he handled cases involving a wide array of financial and computer crimes. In 2010, Joe received a FBI Director's Award for Outstanding Cyber Investigation based on his work in investigating and disrupting a major international computer hacking ring that targeted financial institutions. He held a supervisory position in the legal department of HSBC, where he led global internal investigations and advised HSBC regarding its financial crime compliance programs. Welcome, Joe. And our third panelist, another good friend, Judy Selby, an attorney with Hinshaw and Culbertson. She advises clients on privacy and cybersecurity matters and applicable laws and regulations. She's one of the well-known privacy attorneys in the country. She has drafted a number of papers. If you follow Judy on LinkedIn, you'll see that she's an amazing writer, and she always informs the community in terms of the latest and greatest as it relates to the topic. She's a co-founder and co-founded an e-discovery and information governance team at AM Law 100 law firm. And she's also the author of 3 ebooks, A Closer Look at Cyber Insurance, Demystifying Cyber Insurance, and Big Data for Business Leaders, which I highly recommend you guys to take a look at those publications. With that said, let me just go ahead and kind of give you an overview of why privacy and why are we here to discuss this matter, why is the big deal. As you know, privacy has become a challenging topic for most organizations and governments over the course of the past 10, 15 years, especially due to digital transformation and the amount of data collection that we see has complicated the situation, from financial institutions, which heart of the transaction processing is data, to telecommunications, to even smart buildings. You can see that the data is all over the map. And as a result of that, organizations really needed to take a step back and look at their data privacy strategies to be able to create that balance between customers' expectations, which is convenience, but also aligning it with the increasing regulations. So we'll discuss some of these points in terms of some of the hot topics as it relates to privacy and balance with regs, especially since we have 2 very educated and smart attorneys on the panel. Data privacy also is not unique to companies. It's covering governments and institutions across the globe. It's a very complicated matter because when you're trying to implement a solution or a capability at an organization, you have to look at it from a global perspective if that data is moving cross borders. So we'll try to cover some of those points as well. I'm sure you've also heard in recent years that because of some of the surveillance requirements that governments are imposing on organizations, there is also some conflict between companies that are trying to keep their customer data private and governments that are also trying to have some level of visibility into the data that is processed. For the sake of national security and in the COVID-19 days, we know that the health data is also another important factor that is part of our personal information. So from a standpoint of, organizations that are monetizing our data, like Google's and Amazon's of the world, and share our data with various businesses, and at times not transparent to us. We need to understand what's the best approach to be able to handle some of these issues or challenges as it relates to privacy. So with that said, I would like to take a first question to each one of our panelists related to, kind of describing how did they get to this level in their career, specifically around the areas that we are covering. If they can give us kind of an overview of their career path, that would be very, very helpful. So why don't we start with you, Mark?
Thanks, Shahryar. So Mark Clancy here. I actually started out probably the most different of the panelists. I am not an attorney. I actually started out as an electrical engineer, worked in heavy industry, in nuclear power, chemical manufacturing, steel, and decided that I'd rather go to a place where I didn't get killed during the day. So I actually switched and started doing work in other service industries and wound up in financial, which is where I met Shahryar when I was at Citigroup. And then from Citi, built out security program, really focused on the operational sides of things, dealing with incident response, responding to what we now call phishing attacks, those kind of things, and recognizing that the environment we built needed to be upgraded in face of the threats that we had. I then went to the Depository Trust and Clearing Corporation. Many of you may know it, some of you may not. DTCC is basically the entity whenever you buy or sell a stock, it moves the shares to the buyer and the money to the seller. And it's a financial market utility. In fact, it's 3 of the 8 in the US. And there I built out a security program and started dealing with the geopolitical issues. This is around the time that the presence of nation states beyond espionage started to emerge. And I spent a lot of time in Washington and Brussels speaking with legislators about privacy and security, because now these 2 issues are being commingled, and what we should do from a public policy perspective and what our viewpoints were. I then accidentally started a cybersecurity company and spun it out of DTCC. Then as Shahryar mentioned at the beginning of my introduction, my last major corporate role was at Sprint, where I had the privacy and security function, not the privacy function, the security function and the fraud function, and interacted a ton with the privacy team because of course, telecoms, particularly mobile phones, have tons of data about their customers, how we protect all that. And underlying all of that has been dealing with the various twists and turns in global regulation around security and privacy and where data can live and what you can do with it. Look forward to the rest of the panel. And Shahryar, I'll hand it back to you.
Thank you, Mark. Mark, just to quick point, since you're very much focused in cybersecurity over the course of your career, have you seen a closing of the gap between cybersecurity or information security and data privacy in the organizations compared to many years back?
Yes and no. I mean, the short for me is if you think of security as protecting data and privacy is ensuring that the data is only used for the purposes which it was gathered, right? Those 2 things are related but separate. What I've seen is a lot of people realizing there is no privacy if you don't have sound security. And I'd say that's the most positive development over the last decade and change. But I think there are some implementation differences that are quite different. And sometimes in the protecting things from a security perspective, we have to manage privacy trade-offs and risk management decisions about what information do we use for what purposes and how did we gather it. So there's still a lot of work to do there, but I think the recognition is that there is no privacy unless there is security has become more well understood.
Yeah, and I've noticed that in recent years, especially from a career perspective, privacy, and I'm sure that Judy and Joe can speak to that. Privacy used to be covered mostly in compliance or legal, and now the role of data privacy officer is more of a coordination role between various functions within an organization, and it's becoming more and more of a visible role in the organization. So.
Yeah, and for sure, the business risks related to get privacy wrong have escalated over time as well, right? And I'm sure some of the other panelists will cover that. And so it's become something that's not just a check the box approach. It's really a business risk management issue that has both legal and operational elements woven through it.
Right. Thank you, Mark. Joe, do you want to kind of give us an overview of your career path?
Yeah, thank you, Shahryar, and thank you, Mark. I think it's great that you're not a lawyer because you probably actually know what you're talking about in this space in terms of the technical aspects of it. So let me tell you about my career path. I started as a federal prosecutor at the Southern District of New York I was there for about 9 years. And I handled mostly sort of white collar crimes, things like bank fraud and, sort of money laundering and things of that nature. About 2 to 3 years into my time there, I got pulled into some, pretty major investigations of international computer hacking rings, that focused on the financial sector, and really, did some really interesting work along those lines, and got a real sort of taste of the whole ecosystem of how, an Eastern European hacking ring can, do everything from develop the malware, to get, to steal people's, account information or whatever it is that they're looking to steal, and then, have a whole money laundering ring to get that money from the United States or Europe, Western Europe, to back to Eastern Europe for profit, and spent a number of years doing that. I also got involved in some intellectual property theft cases, and then later focused on Hacktivist and Anonymous and Lulzsec, if you remember those takedowns. If you read Michael Lewis's Flash Boys, the discussion of the Goldman Sachs computer programmer who was arrested and prosecuted for stealing trade secrets in Goldman Sachs, is my case on the federal level. If you watch Mr. Robot, some of the plot lines there were taken from some of the investigations I was involved with in terms of hacktivists. That all became very interesting and sort of kept me focused on that area. In private practice, I've drawn on that experience to advise clients, obviously, on cybersecurity issues and data breach issues, dealing with law enforcement and sort of having an effective breach response, and making sure that the regulators are satisfied and that the company's in a good position if they were to get sued by their customers or shareholders. That's branched out to dealing with privacy, because as Mark said, you can't have privacy if you don't have security. And privacy has also become, a much more important issue to regulators as well, where regulators are fining companies for, for privacy violations, not, even if there is not a breach, or a cybersecurity issue there. For about 3 years, I was a deputy head of HSBC's Global Internal Investigations Group. And while I was in that position, I handled, obviously international investigations of financial crime matters, but a huge component of that was dealing with data privacy issues when you have an investigation that touches upon, half a dozen different jurisdictions around the world. And, you all need to get that data eventually, to one central location, whether it's London or Hong Kong or New York, and then, disclose it to regulators if necessary, or, just the challenges in maintaining a financial crime compliance monitoring system or an AML monitoring system when you have jurisdictions that say customer data can't leave the jurisdiction. Nowadays, at Murphy McGonigal, I'm the head of the firm's cybersecurity and data privacy practice. I advise businesses and individuals on data breaches, computer hacking, privacy, and cybersecurity compliance. Just to give a sample of my day-to-day, right now, in terms of active matters, I'm advising a foreign company on its US and EU privacy policies. I have another business that thinks it may have been a victim of a data breach a number of years ago, and what should they do about that? I have a business that's been a victim of identity theft, essentially, including its principal owner. And then I also have, someone who is in negotiations with their former employer about, allegedly, having taken some confidential information from his former employer. So that's just a cross section of what I handle. I found this to be, an opportunity to be involved in cutting edge law that's really developing, as we speak. There's a new twist and turn every day, and we're going to talk about the legal issues. And so I think I'm going to give it back to Shahryar and let Judy answer this question as well.
Thank you, Joe. Appreciate it. Judy, if you can give us an overview of your career path. And one thing that I wanted to point out about Judy, she's also very focused and specialized in cyber insurance, which is an area that may not be covered in depth during this session, but we'll have a touch on it. So Judy, please.
Thanks, Shahryar. Hi, everybody. I'm really excited to be a panelist with Joe and Mark on this. Thank you for the opportunity. I've been practicing law for almost 30 years. I'm an insurance coverage lawyer, meaning I get involved in disputes between insurance companies and their insureds around coverage under the policy for various types of incidents, lawsuits, whatever the case may be. I've always handled very, very large, complex cases back in the day involving lots of paper, literally warehouses full of boxes of documents. And then, over time, it became electronic data. And I always handled these large cases with lots and lots of data, which led to me being asked to come in and manage all the e-discovery and handle all the evidence in the Bernie Madoff litigation on behalf of the trustee. And so we had lots of very, very sensitive information, from Madoff's corporation, as well as from investors and companies, basically all over the globe. So I was in charge of, kind of managing all that information. We got involved in a lot of cross-border issues involving, subpoenas for documents from countries in Europe or Asia. And so dealing with the issues that Joe was just bringing up about the complications around all of that. Right around the time I was doing that, cyber insurance started to become a little bit more well-known. And so I took a very, very deep dive into that. So everything kind of got married together, the data management, the rise of regulations around security and privacy. And I was so glad to hear Mark and Joe both bring up this issue of cyber and privacy being related, but being very different things. And I think a lot of people conflate the two. They're quite different. And as Joe said, there's tremendous risk associated with privacy, even if you never have a data breach. So I think that's very important for people to remember. So my day now, I do a lot of the same things that Joe does, but I also do quite a bit on the insurance side, advising companies on appropriate coverages, whether things are covered or not, work with insurance companies on language for their policies, and looking at whether certain types of claims are covered under their forms as well. I do more on the proactive side in terms of compliance, helping companies deal with these emerging regulations that we're going to speak about. And then a little bit on the reactive side as well, what we call the incident response type of thing, the types of matters that Joe was just speaking about.
Great, thank you. Thank you, Judy. Okay, so amazing and great career path by all three. And I'm sure that our audience, especially since majority of our audience are students from Columbia, would really appreciate that. So let's start some of the topics that we want to cover today, starting off with level setting with the audience and with ourselves in terms of the context of privacy from a definition perspective, in the context of corporate policy, which we know organizations have made significant focus and changes in recent years due to these types of requirements. So we have corporate policy that needs to address privacy. We have global and local regulations that are constantly increasing. And of course, the most important thing, which is individuals' privacy rights. And us as individuals or subjects, when we use the term privacy, individuals, us as subjects, we have an expectation from our service providers, looking at how governments are tapping into our data, and trying to create a balance between these three. What I'd like to ask each one of you to define is, what is privacy from your lens in the context of these three areas, which is corporate policy, local and global regs, and individuals' privacy rights? Why don't we start off with Mark, please?
Thanks, Shahryar. So I'll sort of go back. I'll go in reverse order, perhaps. So I think the first thing, we'll talk about this more, is that each individual on the planet has their own expectation of what is private and what is not. And so one of the challenges that we have in any type of implementation is this expectation management of, what do I think it is? What do you think it is? What does somebody on the other side of the globe think it is? And there is no single universally accepted by humans definition, because every person has their own perspective, history, et cetera, right? So then we get to the second one, where we have the legal frameworks that exist. Those are trying to distill within a geography of some shape what the collective thinking is about the expectation around private information and what information can be used. That is very different around the globe. It's even different within small jurisdictions, right? You know, you go from Switzerland, and you go across the border to Austria, and it's different, right? It's kind of those issues. So you've got some locality and some just societal expectations that get aggregated in some set of rules. And then when you get to the corporation, now you've got to take all these rules, some of which mentioned earlier conflict with each other, and figure out how do you go implement them in a way that your institution can be consistent about how things are done, and get everybody in your company on the same page about what's okay and what's not. And for me, that's been the implementation side of this has been really difficult, right? Because the previous two items, the jurisdictional issues and the individual expectation issues, sometimes change very fast. And particularly, we'll get into this much later in the panel, but with the technology that we're using now, societal expectations on what is private and what is not can change with a couple hundred tweets, right? So that would be my answer, Shahryar.
No, that makes a lot of sense. Thank you, Joe.
Thank you, Shahryar. So I think for me, the answer to this question depends on which hat I'm wearing at any given moment. You know, as an attorney working in this space, advising clients, I'm very practical. Privacy means whatever the law I'm being asked to apply says it means. I'm just trying to help the client understand what its obligations are under the law, and how they can integrate those obligations into its business in such a way that they've sort of balanced all the risks and minimize, you know, the impact on their business, you know, in terms of being compliant. You know, I also teach a class on cyber law at Cornell University's Tech Campus on Roosevelt Island, and you know, we spend an entire class discussing philosophically what privacy means. And so, you know, along the lines of what Mark said, you know, everyone has their own interpretation of it. It's not something that can easily be defined. Personally, I think it means carving out a space where, you know, each person, you know, can live a part of their life, you know, without being under observation, you know, for other reasons by others. I think the challenge and the reason why privacy has exploded as a sort of legal area is because as more and more life gets conducted online, the opportunities for surveillance of any nature, whether it's private or government surveillance, becomes, you know, much more acute, and it gets harder and harder to carve out that private space. And so managing people's expectations of what should stay private, you know, and balancing that with, you know, legitimate needs of businesses and governments is sort of the reason why this is becoming such a big issue.
Makes sense. And one of the topics we cover in one of the courses that we teach within the enterprise risk management program around cyber and privacy relates to very much of this topic, which focusing on risk quantification, and aspects of risk quantification addresses some of the privacy requirements that are tied into these issues. Judy?
Yeah, I share, you know, the definition, quote unquote, that Joe and Mark just described. when I work with my clients, you know, as Joe was saying, we're very much focused on compliance and just doing what you're legally required to do. But I always like to kind of convey some principles that companies should keep in mind, regardless of you know the X's and O's of any specific law or regulation that they have to deal with, or a contractual obligation that they have to deal with. And it's this concepts of, you know, being transparent, being ethical in what you're doing with your information. There's a phrase I like to use called lawful but awful. So, you know, with regards to decisions that companies are making with information that they have, particularly consumer information. We see there's a lot of things that you can do technically now. And Shahryar, you're an expert in that area for sure. But just because you can do something doesn't mean you should do something, whether or not it's addressed by a law or regulation. So you want to avoid the lawful but awful type of situation that a lot of companies have done and get themselves a big, you know, kind of black eye in the press or in their relationships with their customers or their clients for that reason. You also want to have a level of accountability to your consumers or your business partners, if something goes wrong, if your data becomes inaccurate or whatever the situation may be. That level of accountability is really important. And to kind of sum it up, you know, from the lens of a corporation, you want to, you know, say what you're doing, that transparency component, say what you're doing, but also do what you say you're doing. You know, two different concepts. If you put something in your privacy policy and your privacy notice, make sure you really are doing that. That's really key. And it's challenging. It's challenging to get compliant. It's challenging to stay compliant. So it's important not to look at this as a project. You know, it's a process. It's just going to be an ongoing process for, you know, because we're a digital economy now. So this is just the way it's going to be.
Yeah. That's true. If we go to the next slide and tee up the discussion on the differences from a balance, keeping the balance, what I would add to what was said by Mark, Joe, and Judy is that, you know, just like Mark pointed out at the beginning of his answer, privacy is viewed very differently from a cultural perspective. I teach a class that is comprised of a number of international students and folks from here in the US. And, you know, when you start looking at some case studies, you see that even the view of individuals based on the culture and where they're grown and raised and kind of adopted those types of characteristics are very different. Even if I would say in the US, if you take a survey around how private your children's data needs to be in one state versus another state, you probably would get very different results. So to that extent, that is something that, you know, we always kind of try to say, okay, if we have to develop something global, how do we make sure that you know, we are addressing the core of what we are trying to, you know, achieve, but at the same time manage these differences, which complicates the matter. So from a cultural perspective, what I'd like to do is maybe ask Mark, you know, there are organizations that you and I worked for, like Citigroup, where I remember whatever we did, we had to roll it to 153 different countries. Can you share some of those experiences from a standpoint of cultural differences when it comes to
actually I'll give an example, which is sort of cyber meets privacy, right? So many years ago at Citi, we were implementing a technology solution called data loss prevention, right? We were trying to make sure that sensitive data did not float out the door via email. And as we implemented that, we had to literally have a country by country implementation approach because the rules were different and the expectations were different. And so as we implemented in the US, there weren't a lot of legal constraints at the time, right? We could do it. We had to figure out what to do. And then in there, we were managing how do we sort of neck down the problem? So, you know, 10,000 credit card numbers in an email, we should start there and then go down to 500 and then 100, then 10, then 1, right? So we had sort of a technical implementation approach. But when we got to Europe, we had the intersection of two things. We had the protection of customer data and the privacy of that data. And so the program we were implementing was good. But we then also intersected with the privacy rights of workers and the company's ability to surveil and direct what they did. So we had to have a country by country meeting with the management team, the labor representatives in places like Germany, the Works Council, to talk about the business practice. And at that time, what we actually did is we did the countries that had the most complicated implementations last and pointed to the control we put in place in the rest of the world and say, well, don't you want that protection for the end customers here? We need to come to accommodation with the workforce around how do we manage this intersection. And I use that as an example because it's the kind of thing that you have to tackle this puzzle and come up with an implementation strategy that can demonstrate what you've successfully done in other jurisdictions to get comfort in jurisdictions where they're more hesitant. Now, things have evolved quite a bit since then, and some of the rules have changed, right? But that's just an example of this complexity in a global institution. Is there's no one project to implement. There were 153 projects to implement, and probably 300 sets of lawyers that we had to go through everything with, right? You know, one in each jurisdiction. So.
Yeah, they always say, think global, act local, right?
Yeah,
So.
and career tip, don't be on vacation the week they're deciding who should get the project because they'll give it to you.
Yeah, Joe, you've had some experience at HSBC, as we did the introduction with you, obviously one of the, I think it is one of the largest retail banks in the world. Do you have any experience from a standpoint of, you know, cultural differences when it comes to implementation of privacy?
Yeah, I do. I think, you know, first, you know, putting aside whatever the law is, you know, you need to approach this problem with a good deal of cultural humility for yourself around your understanding of privacy. You have to sort of recognize that there's no one right way to do it, that people all over the world and different cultures have very different experience, you know, expectations for privacy than you may have, you know, that, you know, if you grew up in America or Western Europe, you have certain notions of what privacy is. And you need to sort of really just be in listening mode rather than going in thinking that you're going to dictate any terms. I think so that's one big issue, is to sort of just be open to vastly different ways of doing things. I think another sort of tip that I had is you do need to, it's very important to listen, but you do need to throw away the rule book. Like any large organization, you know, HSBC had lots of rules and policies around privacy and, you know, specific country level policies, you know, for different jurisdictions. But, you know, you would look at the policy and I would look at the English translation of a specific country's privacy law, and then talk with the local team, and they would tell me that, you know, that may be what the law says, but the local regulator expects something different, and they want to stay right with their local regulator, right? So and that's very important. So, you know, you do need to sort of look at how, you know, regardless of what the legal requirements are, what you might be expected to do in that jurisdiction that goes beyond the legal requirements. Some of that is a little bit of the lawful but awful, you know, sort of third rail that Judy mentioned, and you know that you know, as if you're talking about a different culture, what's considered lawful but awful, you know, is going to be different from what you might expect here. I can guarantee you disclosing any personal data to the U.S. government anywhere in the world is going to be considered lawful but awful. So you know, that's something you need to consider. And I think, you know, ultimately, you know, after you've listened and you've sort of, you know, gotten buy-in, you know, or, you know, from the local teams, and they understand that you're not there to sort of dictate to them, then you just sort of need to come to some sort of practical resolution of this that balances all the risks. There may not be a clear path forward, and ultimately the business has to make a decision on a higher level about, you know, who they're more willing to piss off potentially, you know, when they're trying to resolve an issue.
Okay, and that's true. And you know, I think Mark pointed out that when you're looking at implementing a solution or a product of your business from a global perspective in the lens of different regulations that are evolving. You have to kind of understand the most stringent, if you will, set of policies that is applicable from a legal perspective that can be applied to all. And even in organizations that I've worked for as a consultant in the US, if they're covering multi-state sort of presence, we have to kind of look at the state that has the most stringent regulation and implement those requirements, and then that hopefully checks the box with the rest of the states. So that's definitely important. But it is a complicated situation, because in every situation, and it has changed significantly in recent years, as you know, the data that is processed through a transaction, it's important to understand where is that data, sitting at, who has access to it, and then some of the cross-border issues that we'll have to deal with. So it's something that we face with, and we will more and more, given that the data moves all over the map, especially when it comes to transaction processing of a lot of these organizations that over years have tried to change their topology, try to go to like low-cost locations and move their data centers there, or consolidated data centers to save cost. And then as a result of that, the presence of this data across the globe shifted in the lens of cost savings and or some of these a banking transaction, let's say a mortgage processing transaction, believe it or not, if you initiate a mortgage transaction here, your data goes to multiple locations around the globe. Again, because these data centers that are located by design to be able to process your transaction from a COE center of excellence perspective. So these are some of the challenges that is always something that we need to deal with. If we go to the next slide, since we have two great attorneys on this panel, and of course, Mark can talk about, implementation of those legal interpretations. I wanted to kind of change the discussion a little bit around legal and the regulatory landscape. It's obviously very well known that, we heard in the past so many years that European Union has started, given their culture around privacy and protection of their citizens' data, started to come up with a number of rules. One of the well-known that we have been, and the rest of the globe had to deal with in terms of implementation of that law, GDPR. And then in recent years, California came with California Consumer Privacy Act, CCPA. So a lot of focus by organizations in this area. So I wanted to kind of get your perspective in some of these regulatory landscape, and both for Joe and Judy, any recent enforcement actions that might be interesting for you to share with the group. So with that said, I don't know, Judy, you want to take it?
Sure, I'm happy to. There have been some, there's been a lot of activity, more and more activity now in the space in terms of enforcement. Some things to keep in mind, though, we can, and I think Joe has some good information on this, we can talk about the huge penalties that are, fines that the regulators have issued recently against some very big corporations. But one thing to keep in mind, sometimes I think those penalties have an undesired effect on other companies, because I'll say, well, they just fined Facebook $600 million. They're not interested in me. They're not interested in my business. I'm a small business. I'm a medium-sized business. I won't be impacted by that type of a thing. And that's a mistake. One thing to keep in mind is that there are some regulations currently on the books and laws, others being proposed throughout the country, that provide a private right of action, which means that consumers themselves can file a lawsuit for at least certain types of violations of certain laws. And so that private enforcement is something to keep in mind, especially when we think back what we were talking about just a few minutes ago about alienating consumers by certain things you're doing with their information or lack of transparency, things of that nature. So that's something I think that's really key to keep in mind. Another thing to keep in mind in terms of enforcement is it's not just fines, it's not just lawsuits. Regulators can come in, like the FTC did fairly recently, and say, we're going to install, you have to have a privacy monitor for 20 years. You have to create subcommittees on your board of directors to address privacy issues going forward. So a real practical, kind of equitable relief, as we lawyers call it, that force companies to try to not just pay for past wrongs, but implement systems and controls, not in a technical sense, but in an operational sense of how to prevent these things from going forward, from happening in the future. And Joe, I think you have some good data around some fines that you were going to discuss. Is that right?
Yeah, I was going to talk about a few recent enforcement actions. So I'm happy to jump into that, Judy. So, I think I echo everything Judy said, just on a high level. I mean, we could spend an entire day talking about the current developments of the legal and regulatory landscape for privacy around the world. I was going to focus on just a handful of very recent developments. I do agree generally, though, that smaller businesses or mid-sized businesses have felt they can escape the scrutiny. Hey, Facebook got fined $5 billion for violating the its prior consent order with the FTC. I'm not Facebook. So what do I really need to care? Or yes, hundreds of millions of dollar penalties gone out to some companies for not notifying their customers of a data breach that affected those customers. But I'm a small, financial institution. I'm a small business, so what if a couple, thousand or, customers, records a breach? Why do I need to do this? As Judy said, the private right of action in the California Consumer Privacy Act, which has statutory damages for data breaches, can change the calculus. Illinois, biometric privacy law, has a statutory right of action, private right of action as well. Facebook settled a lawsuit for, I think, $550 million under that. These are, there's a plaintiff's bar out there, not just regulators that are looking to take advantage of these laws. But, generally, I wanted to focus on just some very recent developments, just to give the group here today just some up-to-the-minute stuff. So on the legal side, the law side, earlier this month, sort of hot off the presses, California approved what was known as Proposition 24, the California Privacy Rights Act, which is, if you know about the CCPA, is basically a suite of amendments and additions to the CCPA. And I think for folks who are not sort of clued in entirely in the background, it makes sense to spend a minute on that. But if you go back to 2018, the CCPA was the brainchild of a real estate developer in California who thought that tech companies had too much personal data and needed to be regulated. His name was Alistair McTaggart, and he formed a group that put forward the California Consumer Privacy Act as a ballot initiative in California. And if you know anything about the way ballot initiatives in California work, is that once the public approves a ballot initiative, the legislature's hands are tied in terms of getting rid of that law. It becomes part of the California code, and the legislature has very limited ability to change the laws. So the only way you can get rid of it is through another ballot initiative. There were a lot of problems, from whatever perspective you had, about the way the CCPA had initially been proposed. And so McTaggart cut a deal with the California state legislature that they would pass a law that was acceptable to him, and he would withdraw the ballot initiative. And it was a very rushed process. And if you've worked in this space over the past 2 years trying to get companies to be compliant with the CCPA, you've pulled your hair out just trying to understand what the heck the law means in certain instances, and the different conflicting regulations that the California Attorney General has come out with, and revised and revised again and revised again over the past few years. And so it's been kind of a mess. And into that, McTaggart came out last fall and said he wasn't happy with the way the CCPA ultimately ended up, and he wanted to make some changes to it. And so he put forward this new ballot initiative, which is now the California Privacy Rights Act, the CPRA. And just very briefly what it does, and like I said, we can talk about the CCPA all the time, all day, but it does make some changes to the CCPA that make it align more with the GDPR in Europe. So it adds a category for sensitive personal information, which is like the special categories of personal data under the GDPR, and gives consumers the right to limit the use of that data by businesses. It adds a right to correct data, which was missing from the CCPA originally, but exists in the GDPR. It imposes stricter terms and contracts for the sale of data. And it clarifies a big ambiguity, or something that a lot of people spend a lot of time thinking about in the CCPA. You probably heard of the "Do Not Sell My Personal Data" button. Sale was defined as any sort of exchange of personal data for consideration of value, and a lot of people tried to figure out, what the consideration was. It's not just money; it could be other things. The CPRA now says, basically sharing data, personal data, without any kind of consideration is still considered, it's not considered a sale, but it's considered sharing, and can be, consumers can ask, and demand that not be shared, their data not be shared with anybody. It does some, it adds a restriction for profiling, sort of similar to profiling automated decision-making under the GDPR. And I think, in terms of good news for businesses, it extends the business to business and employee exceptions to the CCPA until January 1st, 2023. One of the big issues under the CCPA is did employers have to provide these rights to their employees in California? There could be some awkwardness if their employee demands their entire personnel file, and things like that. And so a lot of that had been carved out in a legislative amendment to the CCPA that was set to sunset, January 1st of 2021. Now that's extended to January 1st of 2023. And the same thing for business to business, interactions. If you collect personal information of an employee of a business that your business does business with, do you have to give that employee the full suite of rights under the CCPA, and you don't. And again, that's now extended to January 1st, 2023. I guess one other big thing about this law is that it creates basically a data protection authority in California. It creates the California Privacy Protection Agency, and that will be devoted solely to enforcing this law. The Attorney General in California has complained a lot about the CCPA, about the enforcement obligations they have, about the fact that they've had to make all these regulations to implement certain parts of it. And now there's going to be a new agency that's going to be funded in part by the fines it collects from folks who violate the California privacy laws. And all this comes into effect in 2023, and enforcement begins in July of 2023. So a lot more work for people who just thought they had finished with California. So that's a legal development that's very, very recent, as in this month. I do want to mention a handful of enforcement actions over the past 2 years. I think in the U.S., there's, I think due to COVID, I've seen, haven't really been sort of, blockbuster enforcement actions, that we've seen, picking up pace the last few years. But again, earlier this month, the FTC came out with enforcement against Zoom, which is very timely since we're using Zoom now for this, and everyone uses Zoom probably multiple times a day as a result of the pandemic. And that was, as Judy said, one of these instances in which Zoom is now going to have ongoing obligations to protect its users' privacy better than it was doing in the FTC's opinion. And if Zoom were to violate this agreement that they have now with the FTC, they could be fined a lot of money. And just the specifics there, this is one of the classic cases of the FTC getting angry with a company. And again, this is what Judy had mentioned earlier, for not doing what it said it was going to do when it told its consumers that it was protecting their privacy, that it had, end-to-end 256-bit encryption, et cetera. And it actually wasn't doing a lot of that and was leaving customer data exposed. It was storing meetings, recorded meetings unencrypted on its servers. It was leaving, cryptographic keys that could allow access to its customers' meetings, like open for people to get. And so, that's, the FTC investigated, found that they weren't living up to the promises they had made to their customers, and imposed a series of requirements for them to improve their cybersecurity and privacy posture. One thing to note, the two and this is going to be important going forward with the change of administration, the two Democratic commissioners on the FTC filed dissents to this resolution, and their dissents, basically said you should have fined Zoom. You didn't do this. This resolution just imposes a bunch of meaningless, requirements to reform their privacy policy. You didn't provide any assistance to anybody who might have been a victim of, of a breach as a result of Zoom's practice. You didn't really provide any help to the victims, and you should have really held them more accountable. And I think, once, the Biden administration gets a chance to appoint, once this shift between, the Republican-led FTC to a Democrat-led FTC, I think you're going to see, a lot more enforcement that could have some, some monetary penalties in addition to, sort of imposing a monitor for 20 years. Over the summer, the New York Department of Financial Services, which is a very powerful financial sector regulator in New York State, came out with its first enforcement action under its cybersecurity rules that it came out with, a number of, maybe 2017, 2018. The New York DFS, as it's known, had these sort of very strict cybersecurity rules that it issued for the entities that it regulates, which are insurance companies and any sort of bank or financial institution that is licensed to do business, that gets a charter to do business from the entity. And they went after and people were wondering when they were going to start enforcing their cybersecurity rules, and they finally did. They went after a title insurance company that for, maybe 5 years had, millions of customer records, exposed on the internet that were not encrypted, that if you basically knew where to go to get them, you could get the information from them. They brought an enforcement action. The title insurance company is resisting the allegations and intends to sort of fight, them at a hearing. But the New York Department of Financial Services says they consider, each individual instance of a customer's data being exposed to be, a separate violation of the statute of the law. So it could be $1,000 per record. So if you're talking about millions of records, there's potential for a very huge fine down the road, if the company is found responsible for this at the administrative hearing that they're going to have. And then, I said that in the U.S. there hasn't, there haven't been, the sort of series of blockbuster settlements and resolutions that maybe we saw in 2019 and 2018. The European data protection, authorities, have been steadily fining folks over the past few months. And so again, earlier this fall, H&M was fined, 35 million euros by one of the German DPAs. And they found that H&M was maintaining excessive details about their employees' private lives, documenting where they went on vacation and illnesses and personal information. And it was available to managers in the company. And then someone made a mistake and made it available to everybody briefly. And that's what prompted the investigation there. I think, the European data protection regulators are doing a much better job, than the regulators in the U.S. right now of going after smaller businesses, for violations of the GDPR, and they are not hesitating to fine people. So, if you are a business that has exposure in Europe and are established there to some extent and have assets that could be, that could be put at risk, you do need to pay attention to the GDPR there. And I've talked enough now, so I'm going to turn it back over to Shahryar or Judy or Mark if they have any comments.
Thank you. This was very informative. Yeah. Before we get into some of the more of a cross-border issues or experiences that you have had, I was gonna shift it over to Mark. And you heard about all these regulations locally and globally, and for first of all, putting your your ex CISO hat on at a Sprint. How much of our communication is being listened to or tapped to by the government? I mean, you don't have to give out the secret sauce there, but in general, what I wanted to find out is, how complicated is it to implement all these regulations while you're trying to, serve your customers, and sometimes these conflicting regulations, from FTC versus, other organizations at the state level.
Sure. So let me start with one sort of thing that if you're in a management team and you're listening to people talk, you have to be hearing for, right? Which is companies believing that the data that's created through use of their products and services is the company's, not the customers. And that attitude, which exists a lot in technology, but it's also some of the product management areas, that's the part where I personally believe these companies go sideways and run afoul of these privacy rules and regs, because they have a different expectation of it. Well, I built this product or service, we created this data, therefore we can do what we want with it, even if that's not the case from a legal perspective under the privacy laws that exist. And that just sort of management attitudes where I think a lot of this goes wrong. To your specific question, Shahryar, this sort of conflict management between jurisdictions, right? Sprint substantially was a domestic wireless carrier, but had international business as it relates to, we called it wireline. So like, you want an IP circuit in some other country. So it didn't have as much of that sort of international cross-border element as the core of the business. But the implementation pieces for sure are difficult, right? And in other projects and other companies working on, we had essentially so we were trying to build a global reporting scheme. We had that same thing you mentioned where we're trying to regionalize data centers in the US and Europe and Asia. And the location of where we chose to put the data was a substantially negotiated item, because each local regulator wanted to have sovereignty. So they wanted the data within their jurisdiction. So if they had to send the functional equivalent of the sheriff to seize it, they could get it. Some wanted autonomy. That meant the data was only used, actioned, and processed within that jurisdiction. And some didn't care. We were trying to build one global system to support all those different needs. And the issue for that project, and it was around in the derivative space, was really getting, in order for the solution to work to support macroprudential regulation and risk management, we had to see the whole picture. But you couldn't see the whole picture if you couldn't pull data from this little island and that little island, right? And so there was basically a negotiated piece with various regulators about where things live, what controls and oversights existed. And so instead of having, the original idea was to have 2 locations, I think we wound up with 7. And then we had a way of aggregating the total picture, but desensitizing the data, so transaction level, individual firms and participants data. And so you mentioned on that earlier slide, I think one of the best things we can do as practitioners in implementing is really ask the hard questions of, do we need to create this data in the first place? Do we need to manage it in its raw form? And is there something else we can use to answer the question and build that privacy by design to help deal with some of this cross-border pieces? But in the end, right, and this is a risk management program, right? This is a risk management decision. You are not going to get a perfectly clean answer from Judy or Joe or their counterparts about this is exactly what you can do and can't do, you're going to get this spectrum of, well, here's things that are very risky and these have led to massive fines. Here's things that, you know, you could be pure and white and you never have a problem with, but then you can't actually solve the problem you have. And you spend a lot of time in between those poles in that middle ground. And so you're going to make deliberate decisions. And the one thing I would add to the prior conversation is be very transparent about what you decided, why you decided, and who said it was okay, right? And that's that transparency and the accountability of driven. You may get it wrong, but it's better to have a rationed argument about why you did something that an enforcement agency or regulator might disagree with than just doing something and saying, well, this is what we did. And then you can sort of disagree on the merits and they'll make you adjust if they disagree, but they won't make you adjust with a big, you know, here's $1 billion fine hammer, right? And so it becomes much more implementable that way.
Yeah, for sure. And, you know, the complications around this topic, you know, not only from a technical perspective, but also from a standpoint of even agreeing on some of these issues, like Mark pointed out, because, you know, to do it right, you obviously have to have the business who is the information owner or the data owner at the table. But at the end of the day, other functions within the company, we talked about risk management, which wears a different hat than compliance, than legal, and others within the organization. And how do you bring them all together? I remember back in the days when we were at Citi and we were implementing a certain set of solutions that impacted Citi employees or customers in different parts of the world. I know we had to really coordinate across all these different functions at both global perspective, but also regional perspective.
Yeah, and actually, I'm going to pick up something Joe said about New York State Department of Financial Services, right? So they built their program for cybersecurity and financial services around a risk management view. My practitioner interpretation of it is there's two ways to assess risk. You can assess risk to the corporation, and you can assess risk to the customer. And those assessments of risk, what's risky for a financial loss for a Citigroup is really different than what's risky for financial loss for my mother, right? And so that frame of reference on risk assessment is also very important. And I would ask, when you think about this, don't just assess it from the perspective of the customer, the company, also assess it from the perspective of an individual customer and what's risky to them, whether it's financial or privacy or whatever. And that'll help better inform that decision you're going to make, and then how you manage the subsequent risks around the globe.
Mm-hmm. Yeah, that makes sense. Judy, just a quick, feed from you in terms of some of the less well-known issues that people should be aware of concerning privacy laws and regulations before we shift gear towards more of a cross-border transfer of data types of discussions, please.
Yeah, I think the biggest issue right now is around what's called biometric information, biometric data that can be something that is used to identify a person, such as a fingerprint, an eye scan. It can even be keystrokes, biomechanic information. How long does it take Shahryar to type in his password? That can be used to try to verify whether that is actually you trying to log into your account. For some reason, this has really flown under the radar. I think Joe earlier mentioned the Biometric Information Privacy Act in Illinois. We refer to it as BIPA. That has one of those private rights of actions. And you can't believe the massive settlements that companies are getting into, typically around using finger scans to instead of a time clock. Like, people of a certain age like me remember, punching in, punching out. Now they're using these finger scans, and they're either not aware of the law, they're not in compliance with the law that just requires these concepts we've been talking about, providing information, being transparent about what you're doing, why you're doing it, how long you're keeping the information, things of that nature. So that's a huge issue, especially in Illinois, but there are other proposed biometric privacy laws in the works in various states. There was a biometric privacy law actually introduced in the Senate maybe about 6 weeks ago, I believe. So that's a really huge issue. There was a law introduced in a bill introduced in New York, I think on October 28th. The largest component of it is called the It's Your Data Act, which is very much like CCPA, except for with a total private right of action for any violation. But that bill also proposes a change to the New York civil rights law, which creates criminal penalties for certain privacy violations. So people should be super aware of that. This goes back to something you raised in the introduction, Shahryar, of the role of a privacy officer or privacy official in a company. The communication throughout the company is really, really key. You might have a factory manager who says, yeah, this is great, let's use fingerprint scans instead of punch cards to verify employees' work hours. Somehow that decision would need to be communicated with other people in the organization, so legal, privacy, human resources, whatever it may be, so that they know in advance that this is happening. And somebody can put their hand up and say, well, listen, there's legal requirements that go along with that. There's also ethical requirements, especially around biometrics. You can't call up and cancel your fingerprint and get a new one. It is what it is, unlike a credit card. So to me, that's one of the biggest issues out there now.
Yeah, and to that point, and Mark, you will speak to that, but when it comes to security and the protection of that data, as you just pointed out, with biometric data, you can't replace it. So the level of protection that needs to be applied to that type of data, from a standpoint of protecting against hackers and other types of incidents, is a lot different than, like you mentioned, things that can be replaced. So
yeah,
very high risk.
I mean, and I'll go back to if you don't need it, don't collect it, right?
Mm-hmm.
I've been implementing, the intersection of these things, right, is like lots of things scan driver's licenses, right?
Mm-hmm.
And so I used to live in Kansas, and Kansas's law on driver's licenses, you can't store the license content, but you can store the picture. But then you go to Illinois, well, picture's biometric data because you can do facial rec, right? And so you just have these sort of fragmentations of, we're trying to implement one thing across, retail stores in 50 states. And we have this matrix of what we can and can't do in each place for each element. And, had the legal team and the privacy team on speed dial, right? Every time we want to change anything operational, it's like, all right, here's what we want to do. Here's why we think it's okay. What do we need to think about? And then just expand that out over whatever other countries you operate in. It's just, it's a very complicated puzzle you've got to manage.
I agree. I want to ask Joe to maybe just touch on it for a couple of minutes, some of the cross-border, experiences that he's had. It's also good to understand, when a company is global, let's say US company that is present in EU, and they're subject to the EU laws, let's say, because of that data transfer. How are the enforcements done? If let's say you're a website, you don't have a physical presence or operations in EU, but you have obviously their data, and so how do they even enforce penalties on you when it comes to that type of a scenario?
Yeah, sure. So happy to spend a few minutes on this. So I think everyone knows at this point in time that under the GDPR, there are a number of ways that European regulators can enforce or have jurisdiction over entities that do business solely outside of the GDPR, right? And the most typical ways they could do that is if you are a business located outside of the EU, but you solicit business from EU, data subjects, people who are located within the EU. you are potentially subject to the GDPR, if you collect their personal data. And by soliciting business, it doesn't even mean trying to sell them something for value. It could be any kind of solicitation, even if you're not charging them. It could be. And then the other way is if you engage in the monitoring of behavior of data subjects within the EU. So if you have a website in the US and you install tracking cookies on the computers of anybody who comes to your website, you are conceivably monitoring their behavior in the EU. And so those are ways that I think that everyone at this point is familiar with, that you can get in trouble. We haven't, I haven't seen, and maybe Judy can correct me, but I haven't seen any enforcement actions by a DPA within the EU directed solely at an entity that has no business operations within Europe at all. I think as a practical matter, they might run into some difficulty in, if they want to try and seize assets or whatever, and there's nothing in the European Union, it wouldn't be very straightforward for them to enforce that. There was an instance in which a DPA did warn the Washington Post. They didn't like something that they were doing, but it was just a letter that they sent, and that was that was like maybe 2 years ago at this point. So, I'm not sort of aware of that. I think the biggest development right now with the GDPR and data flows from Europe, and let's just, Europe to the US, quite frankly, is the recent decision this summer by the Court of Justice of the European Union that struck down the US EU privacy shield, right? So if you're a business that has operations both in the EU and the US, and you have various reasons why you want to get data from your EU customers to the US, or your EU based employees to the US. Some of them could be business related reasons. You want to sell stuff to these folks. Some could be, sort of legal reasons, like, if you're a financial institution, you have all sorts of obligations, under, AML laws to monitor transactions. And, if somebody gets added to the OFAC sanctions list, you need to know if you bank that customer, either in the US or Europe. And so, you need to have those data flows going. And one of the ways that non-bank businesses were able to have data flow from the EU to the US was through this thing called the Privacy Shield. And again, just to take a step back to explain why this matters at all, under the GDPR, you cannot transfer personal data from the EU to a country that has been identified by the European Commission as not having adequate privacy laws. If you're going to do that, you have to take there are a number of things that you have to do to make that data transfer lawful under the GDPR. And the reason why the US is considered the worst jurisdiction in the world by the EC for data privacy is because if you remember, maybe I think it was a decade ago at this point, or over that, the sort of revelations from Edward Snowden about the extent to which the U.S. intelligence community can engage in mass surveillance. Of course, the U.S. government has a very different view of all that, and the U.S. even put out a recent white paper, the government, explaining why those fears of mass surveillance are overblown. But in any event, it's caused a lot of problems for businesses that do business in both jurisdictions. And so what so by striking down this privacy shield, it was a sort of a mechanism that was supposed to allow businesses that do business in both jurisdictions to send data to the US. Interestingly, and in some ways a little more troubling, is that the European Court also cast doubt on what are known as standard contractual clauses that also allow the transfer of data from the EU to the US, and basically said, you need to really make sure that the US government is not going to steal the customer's data, if you're going to do this. So a lot of developments there, and a lot of headaches for folks who are trying to figure out how businesses can get data from the EU to the
In
US.
general, I would just add that all politics are local, right? So there's another theme in the European Union, in addition to their legitimate cultural differences on privacy and their desire to protect data of Europeans. They also feel economically disadvantaged because of the success of US technology companies. And so there is also a notion of protectionism built into these approaches. And Germany was actually, it was one of the 5 pillars they had in their program. And I happened to have a super interesting meeting years ago with the German Foreign Ministry right after Eric Schmidt of Google. And let's just say we didn't talk a lot about my agenda because I was the American in the room after Eric Schmidt, and they could yell at me for 45 minutes, right? But it was this notion of both the desire to protect privacy, but also to enable economic growth of why isn't there a European Google, and kind of answering that type of question. And so these things get commingled as well.
Interesting. Judy, I definitely don't want to miss the one quick input from you in terms of, we've heard of cyber insurance, you touched on it earlier, but is there such a thing as, privacy and, damages that companies are trying to recover from an insurance perspective?
Yeah, that's a huge issue right now. Cyber insurance policies are, there are no standard forms. All the forms are different, which creates both challenges and opportunities for companies or people who are looking to get covered. Some policies will limit the regulatory coverage to data breach and security events, as opposed to other companies that will they provide regulatory coverage for violation of laws anywhere in the world that cover how you're collecting, using, storing, even disposing of protected information. So the coverage is there. You have to have a good broker. You have to have maybe a coverage attorney or somebody help you review the policy and make sure the coverage is really what you need. Not every company needs the broadest coverage available, but the coverage is out there for companies who need it. And I'm a huge proponent of getting cyber insurance coverage, but it has to be the right coverage for your business. And it requires some work, some due diligence to make sure you're getting the right form.
Okay, great. We want to thank you for your time. I think this was a great discussion around the topic. I want to thank the panelists, the coordinator of the program, and most importantly, the audience for your time and attention to this topic. So thanks again, and have a great day.